I'm going to talk to you about one of the most common questions that I receive in child custody cases. The question is, can the child tell the judge who it is that the child wants to live with? I usually need to know two things in order to answer that question. Uh, First, where do you live? And second, how old is the child? 13 states do not have statutes that require a judge to consider a child's preferences when deciding on custody. In those states, a judge may listen to what the child has to say, but the judge is not required to listen to the child. All other states, plus Washington, D.C., have a statute on the books that says when a judge may listen to what a child has to say and when a judge must listen to what a child has to say. In those states that require the judge to listen to the child, 14 is one of the most common ages at which the states have that requirement. Another common age is 12. So, for example, in Texas, if you're dealing with a non jury trial, then the Texas Family Code says that a child who is 12 years of age or older and expresses a desire to live with a parent must be listened to by the judge. So the judge must listen to a child who's over 12 who states a preference for where the child wants to live. A child that's under 12 and tells the judge what the child wants to do may be listened to the judge, but the judge doesn't have to listen to the child. One important thing to keep in mind, though, is that the judge is ultimately going to be the one who decides where the child resides or which parent has the right to determine where the child resides. The child can give a preference, but the judge does not have to honor that particular preference. If you want to know more about the law in your specific state, then look to the notes or the description for this video. I'll post a link to your state's laws there.